So that takes us to slice number 4 that we're going to cut through the facts with. We have discovered all of the relevant parties. We have paired up the conflict pairs together using the parties. And we have armed the conflict pairs against each other with claims and causes of action. And then we filled in every cause of action with the various elements that are necessary for the moving party to prove. So what do we do next? Well, we find the facts that support each of the different elements of the claim, and at the same time, we look for facts that will counter the facts that support those elements. We now know what the moving party has to prove it. And how do they prove the various elements of their claim? Well, they use facts. They cull through the fact pattern with various facts that will support their particular side. In any given fact pattern from a law school professor, all facts are likely relevant for some purpose. But you won't see the relevance of each particular fact until you have a rubric to fit them into. It's like a puzzle piece. Sometimes when we're looking at the whole big jumble of puzzle pieces, we don't know how the puzzle pieces fit in with each other. But when we have filled in a good portion of it, then we know that this particular piece fits in with this general area. Odds are, if you have a bunch of facts that you don't know where to put them, well, that's a good indication that you might have missed a cause of action, or you might have missed a conflict pair, because the law school professor, he or she's probably not going to create a fact pattern that has a bunch of extraneous facts. So odds are they crafted these hypotheticals with something in mind. And if you have a bunch of facts that don't fit, you might want to go back one step and think about what other claims might be asserted from one party to the other. And often, if we didn't catch it the first time, we can say, oh, okay, well, this is a fact, for example, involving a statement that someone has said. Well, that would be a good indication that perhaps the intentional tort of defamation might be an issue. It might be a claim that one party might assert against another. So only when you have parsed the facts with the specific intent of finding facts that help prove or disprove an element will they become obvious. You're going to want to scour those facts that support the moving party. At the same time that we're trying to prove the various elements of a cause of action, we're also scouring the fact pattern for facts that will support the other side. We're always looking for facts that cut both ways. The law school book, Getting to Maybe, talks about this concept as being a fork in the facts. An idea that the law is set one way or the other, and it's simply a matter of finding some facts that support and some facts that disprove a particular element. And you might think about that as a logical contradiction, that you're looking through these facts in a way that is both proving and disproving at the same time. But remember, we are always going to be the lawyer for one side and also the lawyer on the other side. And while sometimes the law lets us do that, the law is in one person's favor or someone else's favor, but more likely, and this is true even in practice, the facts will decide the case. There's a famous quote, I don't know who said it originally, but they say that if you have bad law, then pound the facts. And if you have bad facts, then pound the law. But at this stage, we're going to be in the pound the facts mindset. We're going to try and find things that will help one side and also help the other. And it's not a contradiction, because those times where we have a lot of facts on either side, well, that's a good indication that the professor wants you to talk about it. The professor wants you to take facts, analyze them, nitpick the crap out of them, and engage in legal analysis. By this point, we have an idea of what kind of law is going to be discussed. So when you have a particular set of facts that say support one element and go the other way, that's the kind of analysis that your professor is going to want to see. And when we're dealing with the logical shorthand that we talked about before, where we might have one element where there's no controversy, and it's just simply element one equals driving. So, for example, in the Elm Street hypothetical, there's not going to be much of a dispute over whether Drake had a duty to Mary in a negligence cause of action. He was driving. Generally, affirmative acts constitute a duty. So let's think about the example in the Elm Street hypo of Kevin versus Roscoe. At first blush, this might seem like a drop-dead case of battery or attempted battery, which might give rise to an assault. Roscoe has picked up this electrical wire and he has swung it at Kevin. So you might look at the element of intent and you might say, okay, well, Roscoe has a history of bullying Kevin. So that obviously goes on the side of that Kevin is trying to prove. He's trying to prove intent. But switching over to Roscoe's lawyer, you might say, well, let's look at this. He brought the electrical line within 18 inches. 18 inches is not that particularly close. And you might say, if he really had an intent to harm Kevin or give him an apprehension of harm, well, then he would have been much closer. The fact that he only got 18 inches close means that that's something on the other side, and that's a fact that helps disprove the element of intent. And we can go nitpicking through each of the different elements. If it's not a drop-dead ringer for the moving party, then that's a debate. And that's a debate that your law professor wants to see, and it's a debate that will get you points on an exam. You want to keep asking yourself, why? Why does one particular fact help showing a particular element? If we're thinking about Kevin trying to prove a claim for assault, we might think of two things right off the bat. Number one, assault is usually discussed in the same context as battery. And perhaps there is a battery claim to be made based on the idea that Roscoe might have caused some air to blow on Kevin. And perhaps there's a discussion in the torts class about whether air blowing on someone constitutes the harmful contact of a battery claim. But that's probably not going to fly, so let's not worry about that for the moment. So that leads into, what does Kevin have to prove in order to succeed on his assault claim? Well, assault is usually defined as an act that was intended to cause apprehension of harmful or offensive contact, and the act indeed caused apprehension in the victim that harmful or offensive contact would occur. So this is your standard definition of assault, and that is the high-level cause of action, the claim that Kevin's going to make, and each of the different elements that he must prove. So let's talk about the first element, intent. How would Kevin go about trying to prove that Roscoe intended to cause apprehension of a harmful or offensive contact? We know that Kevin is trying to prove his claim of assault against Roscoe. We know that Kevin is trying to prove element number one, intent, and the first fact that he's discussing is the fact that Roscoe has a history of bullying him. We ping pong over to Roscoe, who his attorney is going to say, no, there's no intent because he only came within 18 inches. That's not enough to show intent. Someone who really wanted to hurt someone with an electrical line would have gotten much, much closer. Then we go back to Kevin. Kevin's back on the defense. And he says, all right, well, even if that were true, intent can most easily be proved by what someone says. And lo and behold, Roscoe says explicitly, something like, he laughingly says he's going to electrocute Kevin. That seems pretty clear. We go back to Roscoe's attorney. We say, okay, well, no, that looks bad, but remember, Roscoe said it laughingly. Laughingly can mean he's just joking around. He's not doing it to create an apprehension of harm. He's just being a funny guy. So that argument puts Kevin back on the defensive, and he says, okay, well, that may be, but let's look at what Roscoe does. He lunges at Kevin, and he blows past him. Someone who blows past someone is obviously evidencing an intent to strike them, to come close to them, to barrel towards them with some sort of malicious intent, which goes back to the other side. Then Roscoe's attorney argues, well, blows can mean two different things. That could mean that he lunges towards him and with an intent to strike, but it also could mean that he was intending not to come close at all. If there's just air passing by Kevin, well, then perhaps he didn't mean to come close at all. And remember, the defense only has to disprove one element or show that the plaintiff or the moving party has not proven one element. So the odds are sort of stacked against the moving party sometimes. And that's why it's so important for defendants and the non-moving party to fight tooth and nail for every single element, because the defense only needs to prove one of them. And if they do, then the claim fails, which prevents Kevin or the moving party, generally speaking, from achieving their goal. And it allows the defendant or non-moving party to achieve theirs, which is to not pay out money. So this example shows us that even in seemingly obvious claims, we want to go element by element. Think about which facts support, which facts cut against. And sometimes one fact will both support the moving party and, depending on the interpretation, support the non-moving party. But this is the kind of analysis that your professor wants to see. Your professor wants you to nitpick these facts, to act as a zealous advocate on the moving party's side, and then immediately counteract that on the non-moving party's side. We'll talk a lot about how we structure our essay, but for the time being, just keep that in mind when you're outlining, when you're using the logical shorthand, that you are recognizing what constitutes one of the elements, and then you are supporting it with facts, and then I would draw a vertical line, and I would put non-supporting facts that the non-moving party will use, the defendant will use, on the other side of it. And sometimes one fact will be on both sides of the ledger, and that's fine. You just want to gather the facts that you're going to use in your analysis. And sometimes, if you do practice exams over and over again, you get really good at this. You understand that as long as there's a fact on one side of the ledger and maybe a fact on the other side of the ledger, then that's going to be a hotly contested issue, and it will allow you to think about how you're going to craft your argument without actually writing out everything. It got to the point where in my first year, I took so many practice exams that I simply would outline my practice exams and then not go through the actual exercise of writing out the full answer, because I knew that as long as I had recognized the fact and the right element and the right cause of action, my analysis was probably going to be on the right track. And I'm sure that you can do the same thing. It just takes practice. But this is the kind of analysis, the kind of rubric that you're going to want to use when you're outlining and how to put the facts that you find in the fact pattern into the skeleton, to put meat on the bone, as it were, as you're outlining your factual response. So now I want to talk about a major issue that tends to come up in situations like this. We're on a roll. We've identified the parties, we've talked about the causes of action that they're going to assert, and we're digging into the facts. Unfortunately, naturally, we all want to decide who should prevail. It's human nature to seek the winner, to be emotionally invested in some of the players, even though they are fictional characters that come from the mind of your law professor. You have to stay objective. You have to put your feet in the shoes of one party, and then just as quickly as you do, switch to the other party. And in fact, I think this is probably a good skill for future lawyers to have, to be able to test your objectivity. Clients lie. You can't always trust them. And so it may be that your client was in the wrong, but you don't know because your client isn't being forthright with you. And even if your client isn't lying, they might not be the most sympathetic character in the entire world. You're still going to have to represent them. But more importantly, regardless of the fact situation and how good the different parties are or how evil they happen to be, you're going to have to support them and come up with issues. If not for their sake, then for your sake. You're going to have to put on your objective hat in order to find all of the issues. But more importantly, when it comes to being a lawyer in the real world, being able to understand the good arguments on the other side or the weak arguments on your side, it's so important as a practicing attorney. You always have to anticipate what the other side is going to do before they do it. That's what the game of lawyering is all about. You're always playing this chess match with the other side, and what you do depends on what you think the other side is going to do. So it's important that you not invest your emotions in just one side. Scour the fact pattern for one side and then ping pong over to the other side. When you do this, it's really hard to be conclusory. You're seeing both sides. You see that a certain issue might be up for grabs. And if you see that the issue could go both ways, then it prevents you from being conclusory. And being conclusory is the absolute death when you're writing a law school exam. It's the surefire way to make sure that you don't see all the issues and you aren't able to gather all of the points on the exam because you became too emotionally invested in one side. The key to this is practice. To apply your analytical reasoning to as many fact patterns as you can, and to start to see that nothing is ever set in stone. There's no real black and white on these fact patterns. It's always gray, and you're going to have to argue on one side that it's a darker shade of gray, and you're going to have to argue on the other side that it's a lighter shade of gray. The point here is that analysis is far more important than the conclusion. We don't use the IRAC method, which puts the conclusion squarely in the analysis. In fact, if you look at the IRAC method, the conclusion appears to be one of the four most important parts. But with this system, the Eagle Eye system, the conclusion is almost perfunctory. It's almost completely irrelevant. We would never tell you to put the conclusion first, because once you conclude something, even just writing it down, it prejudices your analysis. So that's why you won't find much discussion in this class of when you're going to write conclusions. Really, the only time we think that you should write a conclusion down is if you know that your professor really cares. And I would say, even if the professor really happens to care about conclusions, it's just an afterthought. Because the conclusion shouldn't matter. You're always going to be talking about marginal cases that could go either way. And this is not like math class where there is a right answer. So what we would say is, if you're going to write a conclusion, and maybe you should, just so that your professor can just check it off when they're reading your essay, what we would say is couch it in probabilistic terms. So it is likely that M would prevail in a negligence suit against Drake. On balance, K will prevail in an assault claim against Roscoe. And that's it. That's all you have to say. Leave it open to interpretation, but don't let that conclusion or your non-conclusion prejudice your analysis. Now, part of the way that you're going to approach these fact patterns is that you're not necessarily limited to only the facts that are stated in the fact pattern. Now, that seems kind of strange because obviously the professor put the facts in there for a reason. He or she wants you to discuss them, and that's absolutely true. But as in the real world, litigators get creative. You're not limited just to what your client tells you. The entire discovery process is there so that you can gather facts. And sometimes, if you come into a case really late and you are in fact limited to what has been discussed, that doesn't mean that litigators can't be creative. It just means you have to pull from logical inferences that you can make. You can still go out and find facts. As lawyers go out and create facts based on their everyday experience, so too can law students. In the real world, lawyers can always ask the court to take judicial notice. You can have the court take judicial notice that on a certain date that the weather was rainy in a certain location. These are usually things that are incontrovertible. And in that same way, you can look at an issue spotting exam and you can add to that. So how would we do that in the Elm Street hypo that we've been talking about so far? Well, let's put ourselves back in the shoes of the Drake versus Mary controversy, where Drake is claiming that Mary was negligent and Mary was claiming that Drake was negligent because somebody is going to have to pay for the bodywork that was damaged when the cars collided. Okay. So, what kind of facts can we create that are not necessarily written down in this fact pattern? Well, let's say you're Mary and you want to prove, remember, we are taking the side of Mary, and her goal is to get money from Drake. Well, how is she going to do that? Well, she's going to try and win her negligence suit. How is she going to do that? Well, she's going to try and prove that Drake was the one that was negligent. Well, we know that Drake was driving 1/10 of a mile per hour faster than the speed limit. But this might not be just any old road itself. This is a road that is 25 miles per hour. Now, common experience tells us what kind of roads are 25 miles per hour? Well, residential roads. And we see some other facts that support that idea. There are children playing. The speed limit is 25 miles per hour. Drake is driving home to meet up with his wife. All of these are facts that might lead you to conclude that he is driving in a residential area. And the fact that he's speeding in a residential area makes it more likely that he is in fact negligent in the way he's driving. Now, of course, this fact alone isn't going to win the day. This is not a slam dunk, but it is slightly moving the scale. And remember, Mary's goal is only to hit 51% on the scales of justice. She just has to prove it's slightly more likely than not. So every incremental step that we can take to show that the facts support her claim that Drake was the one that was negligent and not Mary will help her case. And if you build up enough of those, if you build up enough of a foundation, then she will win her case. So the fact, or at least the inference that you can make, that they're surrounded by houses and Drake is exceeding the speed limit, well, that makes it worse than if he was driving 50.1 miles per hour on a highway with a 50 mile per hour speed limit. It makes his behavior all the more egregious if he's driving this way in front of a bunch of houses. Now, at the same time, we know that we're supposed to take the other side. We're supposed to take Drake's side on this. And what facts might Drake be able to come up with to counteract that inference? Well, he might say a residential road is always two lanes, one in either direction. And he can say, well, look, this is a 4-lane street. So how can it be the case that it's 4 lanes where and also be a residential road. That doesn't make any sense. This was just a thoroughfare that happens to have a 25 miles per hour speed limit. Mary might counter that with the logical inference that there are so many children playing that the only other type of street that is both 4 lanes and 25 miles per hour is a school zone. So she might counteract that by saying it's logical based on these facts that Drake is driving through a school zone and his behavior was negligent because he knew that there were children. There were probably yellow signs all over the place that says it's a school zone. Kids will be crossing. And yet he was so taken aback by this child going into a street, which is a reasonable thing for a child to do, that he freaked out. He went into a different lane without looking, and he caused Mary's accident. Those are an example of facts that you can create using common experience and really digging into the facts themselves. Those are logical things, logical inferences that you can make based on the facts. And that is exactly what your law professor wants you to do. It shows a deep understanding of what is necessary to prove certain elements, what is necessary for one side to prevail. And you're really digging into the fact pattern, and you might even come up with facts that the professor didn't even know were there because of your reasonable experiences. So don't cast aside your common sense when you're doing these law school exams. It's vitally necessary, and that's one of the ways that you will find points that other people will miss, because they will stay at a surface level of these points where you're going to dig in and you're really going to come up with new arguments that one side will use against the other. You're not going to come up with facts that contradict the facts in the fact pattern. The facts are there, and you can basically take those facts as gospel. But that doesn't mean that you can't add on to those facts. It doesn't mean that you can't delve into those facts and come up with logical inferences that will support either side. But so long as you're not contradicting the facts that are there, go for it and be creative. If you're not sure about whether the facts that you're creating are reasonable or not, one thing that attorneys do in the real world is they use a phrase called arguendo. Arguendo is Latin for the sake of argument, or and you don't have to use the actual word arguendo. You can say for the sake of argument, but your law professor will be very familiar with arguendo. Feel free to use it. So you might say, arguendo, Drake was driving through a school zone. Then that means that his this particular fact supports the idea that he was negligent. Or on the other side, you might say, arguendo, if Drake was driving through a residential area, then, and you can go into all the repercussions that come as a result of the fact that you have just created. Arguendo is a great way to be able to argue multiple sides. It doesn't commit you to any one particular course, and it allows you to travel down the option tree that we'll get to in a bit, and get all of the different issues that you might not have gotten to if you stopped at a high level. It's possible that your law professor will give you an explicit instruction not to assume facts. What that means is the law professor doesn't want you to assume unreasonable facts or facts that contradict the facts of the fact pattern. I wouldn't worry too much about that. You're not going to make unreasonable arguments. You're not going to contradict the facts that are in there. But don't be afraid to dive into it. The professor more than likely will be flattered that you have gone so far into the weeds of the facts that they have created. They'll take it as a sign that you are really committed to your analysis. Don't worry about an instruction to assume facts. That's for making unreasonable arguments, not conclusions that you can draw making a reasonable inference. And this is similar to the concept we already talked about when you're looking for parties, you're looking for deep pockets. Well, this particular fact pattern doesn't mention the manufacturer of the telephone pole in the second paragraph. But it's perfectly reasonable to talk about that manufacturer, or in some cases, maybe the manufacturer of the car that Mary is driving. These are ways of getting additional points when you're making reasonable inferences to make arguments that other people are going to miss. And this is a good time to talk about the phrase application. In some versions of the IRAC method, it's IRA meaning application. And it's a good idea to have some application of the facts to the law. But if I had to tell someone in just a short phrase, what is application? Application is nitpicking. Application is digging as deeply as you can into the facts and being relentlessly nitpicking. You're going to be taking a deep dive into the facts because you're going to have to argue both sides. And if you take the role of the opposing attorney, then that opposing attorney is going to nitpick the crap out of the arguments that the first party is making, and vice versa. So application is just simply diving as deeply into the facts as you can, coming up with reasonable inferences, and then nitpicking those reasonable inferences.